Hello, and welcome to today's webinar on protecting political speech while reducing harm on social media. My name is Ashley Johnson, and I'm a policy analyst for the Information Technology and Innovation Foundation. And today we're discussing how Congress, the administration, and social media platforms can potentially reform the ways that content moderation and social media operates in order to continue to protect free speech while reducing harm to consumers. Joining me, I have Will Duffield, policy analyst at the Cato Institute's Center for Representative Government, focusing on speech and internet governance, and Corinne McSherry, legal director at the Electronic Frontier Foundation, specializing in intellectual property, open access, and free speech issues. Before we begin, I'd like to welcome everyone watching the live stream online. Please feel free to ask our panelists questions at any time during the event. If you're watching at itif.org, you can use the Q&A form under the video. If you're watching on YouTube, you can follow the link in the description. Like many contentious issues, the debate surrounding the treatment of political speech on social media has become increasingly partisan, with many on the left calling for increased regulation to ensure social media platforms remove hate speech and misinformation, while many on the right have called for laws that would prohibit social media platforms for restricting users based on their political viewpoints. Both sides, however, blame social media companies for either doing too much or not doing enough, while also overlooking the constitutionality of new laws on online political speech, as well as their impact on free speech and innovation. ITIF will be publishing a report on this topic before the end of the year, where we will be evaluating proposals to reform social media based on their impacts on free speech, innovation, competition, and consumer welfare. But in today's discussion, I'd like to hear some outside opinions from Corinne and Will as we discuss how Congress and social media platforms can balance free speech and harm reduction in the regulation and moderation of political speech online. So as an introduction, and we'll start with Corinne first and then go to Will, why don't each of you briefly explain the work that you and your organization do on online free speech and other issues related to social media?
Sure. So I, as Ashley said, and first, thank you for having me, and I look forward to the conversation. So the Electronic Frontier Foundation has been working on digital rights issues for just over 30 years now. We're sort of one of the leading civil liberties organizations out there, focusing on technology and law. And excuse me. And so we've been working on these issues for a very, very long time. Actually, I started my career at EFF working on sort of a precursor to all this, which some people call the copyright wars, because actually some of the earliest tensions around speech and content moderation in the online space came around, copyright takedowns. And so one of the things I focus on and think about a lot is what we can learn from the mistakes that were made in that space. At any rate, so EFF has been working on these issues for a very long time. We write about them a lot. We sometimes engage in litigation around protecting the rights of people to actually access government media sites and as a way of communicating speech. And I'll close with my intro by also saying that we are one of the founding organizations to draft the Santa Clara Principles, which are a set of principles that we tried to get companies and civil society groups and others to sign on to around content moderation online, protecting things like transparency, an appeals process, and so on. And those are being revamped right now to bring in more international voices, because a big part of what we have to think about in this space is not just the decisions that are made that might affect people in the United States, which gets a lot of attention, but also how they might affect people in other countries, even though many of the leading companies are based here in the US or seem to be very shaped by US values.
I study and write about social media governance at the Cato Institute, a libertarian think tank. And in my work, I try to take content moderation seriously as private governance. These are private attempts to provide governance to and for users. And in that work, I support a legal regime that allows for a diversity of approaches to content moderation, a kind of let a thousand flowers bloom and allow people to figure out what works best for them. I see the internet as a speech ecosystem. Not all speech belongs in all places, but ideally, all lawful speech should be able to find a home somewhere, so long as there's someone who wants to listen to it. So I think those ideas sort of suffuse my work and my approach to the prospect of new internet regulation.
Excellent. And starting with another very broad question, I want to ask each of you what you see as the greatest threats to free speech on social media in the United States. And we'll start with Corinne again.
Well, they are legion. There are a lot of threats to free speech online. And to be honest with you, right, I see two threats right now. I think one of the greatest threats to online speech is extra legal. And what I mean by this is I think that we have a lot of platforms making moderation decisions and making them badly, and under a lot of pressure from policymakers who sort of have an idea like it is possible to have a perfect moderation system. And the reality is it is not possible to have a perfect moderation system. And Facebook pours billions of dollars, well, millions, probably billions now, into improving its moderation systems, and it still gets it wrong on a regular basis. But though all of those decisions that get made are taking speech down, often are taking down lawful speech, and that's a real problem. And the related threat is that policymakers are never satisfied. So it seems like every other week there's another proposal to try to force the major platforms to moderate speech, in yet another way, or do it better, or lose liability protections and so on that they get. And the problem with these proposals is that sometimes they are very divorced from technological realities. Like I saw a proposal this morning to somehow force platforms to provide users with an algorithm-free version, or with a version that it doesn't have the kinds of algorithms that sort of basically moderate speech, and targeting algorithms. And I think that can be very well intentioned, but I also think it's not matching very well with the technological reality. And then, I'm sorry, I'll just say one more thing. The other thing that I really worry about that's not on the radar enough is that a lot of the pressure that we're going to see around content moderation isn't going to stay at the platform level. Instead, we have what I think of as infrastructure companies who are also being pressured to take down speech. And they are so disconnected from the users and from the speech itself that inevitably means that they're going to take down far more speech than is actually objectionable, much less illegal.
So I guess I see changes to Section 230 as sort of the primary threat, and it's just the broadest possible concern. Any kind of change to 230 would affect the entire internet ecosystem. I mean, to some extent, it would depend upon how the change was drafted, but it's a broad-based statute that affects many more platforms than people are usually thinking about when they're complaining about social media or drafting some change to the rules. So it's necessarily going to have a really wide effect. And I think these changes to intermediary liability regulation are often more threatening than direct speech control in the United States, simply because the First Amendment precludes a lot of this direct speech control. And so you could see nasty bills, censorship proposals passed, but struck down quite easily by the courts. I think we're seeing some of that on the state level at this point, and that's why I don't find that quite as threatening. But while the gridlock on the federal level has thus far served internet speech and internet freedom well, it makes procedural efforts to kind of cut through or circumvent that gridlock very concerning, and can lead to hasty kind of slapdash efforts to pass things. Recently, Senators Dick Durbin and Bill Cassidy proposed that their Inform Act, which is a series of identity verification requirements for eBay, Etsy, and other sort of third-party sellers, be included in the National Defense Authorization Act. And this is a kind of must-pass defense spending bill that we get through every year. But by proposing this as an amendment, we may see a kind of rushed thoughtless vote on something that has nothing to do with national defense or national security, but instead regulates Etsy and eBay sellers, merely because procedurally they were able to maneuver it into this must-pass package. So I see both that kind of procedural roundabout mechanism and the informal demands that Corinne spoke about, which I often think of as jawboning, using the power of speech to compel private action, as two sort of unfortunate threats that come about because the protections offered by Section 230 and the First Amendment are so strong, that we get these kind of novel attempts to circumvent that and to push changes through, either formally and quickly or informally just by leaning on platforms.
Yeah, I mean, one of the things that I've found that's challenging is that even when there's a proposal that, we know will never pass First Amendment scrutiny, right? We know that. But people will still vote for it because it's politically smart to do. But even those proposals can have real consequences because the companies really just don't want to deal with it. And so they might adjust their moderation decisions in sort of an ongoing attempt to avoid further regulation. Or, I mean, frankly, one of the things that we've seen around Section 230 is that, Facebook, and I hate to talk about Facebook as if it's the internet, because it really isn't. We all know that, but it's very powerful. And they're like, please regulate us. We would be very happy to rewrite Section 230. And to my mind, it's because they're trying to avoid antitrust regulation or other kind of competition approaches, which are more painful to them than adjustments to Section 230 that they can afford to comply with. But lots and lots of other providers, platforms, but also lots of different kinds of intermediaries rely on Section 230. So those other companies will not be able to afford to comply with these changes, and there's going to have real consequences. There will be real consequences for that. And the reason we know there will be really dangerous consequences for that is that we've seen it with the last adjustment to Section 230, which was very harmful to a lot of marginalized people, some of the very people it was supposed to be helping. I can expand on that more if you want, but maybe the audience knows.
I think the Honest Ads Act provides a very interesting and useful example of this, as its a proposal to regulate political advertising online. Facebook was initially against it, then developed a compliant system at great cost, and unfortunately at great cost to user speech, because in attempting to comply with the drafted but not yet enacted bill, they came up with their own private versions of these issue buckets that the bill would require, which sorts user political speech into a number of sorts of issues and prohibits foreigners from speaking to Americans about certain issues. Now, lots of foreign NGOs that do good work and relied on American donations to fund their activities were under this new Facebook attempt to comply with the forthcoming or proposed law, prohibited from running ads in the United States, and lost out terribly. But now that Facebook has a compliant system, and that we've all seen how hard it would be for everyone else with less resources to build something that wouldn't have the same effects, Facebook has flipped and supports the passage of the bill. And so unfortunately, we get both an example of why it's a bad idea and more pressure from Facebook in favor of it.
Yeah, and I really do want to press the point too that when we talk about Section 230 and some other protections too, the First Amendment, it's very easy to think about just the big social media names that you know about and not realize that, like, email providers depend on Section 230. Users depend on Section 230. So, for example, if you forward an email and it contains something defamatory and you aren't really paying attention, now probably no one's going to sue you, but the whole point is you don't have to worry about it. Okay. And that's important for user speech. And we could have had a very different world. And I don't think we would have liked it very much. The internet would look very different. But I do think we also have to acknowledge that it is a reality that there is a lot of harmful speech out there. There is speech. There are people who are um, uh, find it very difficult to take advantage of some of the big social media services to reach out, as they should be able to, because they get flooded with the trolls come, and if you're targeted for that, it's not a small thing, and it's not something that should be dismissed. And I mean, people will use your address and people will come to your home. Like it's a real problem that I think should be taken seriously. I don't want to, because that is also a speech harm. If you are so threatened that you aren't able to speak either, that's not good. That's not what we want. That's not the world we want. I tend to agree with Will that what we want is a space where there are many, many, many different sites having many, many different conversations. And there is also the ability of many different sites to have their own curation practices and make their own decisions. And when we talk with policymakers, we often try to explain when proposals are going to interfere with that. And I will say, like, look, I want, Ravelry to be able to say, this is a site about knitting, and this is not a place that we're going to talk about X, Y, and Z. And that's fine. I want there to be, a partisan site that says, this is where we're going to talk about these issues, and we don't want to hear from the other side in this place. There should be spaces for that. I think it's also nice if there are spaces where people can all come together. And the thing is to try to figure out how do we create regimes that foster all of that. To some extent, I think we already have it with Section 230, at least before the last revision, which EFF is hopefully going to get overturned pretty soon. But I'm referring here to SESTA FOSTA, which changed the law so that it became extremely difficult to host information related to sexual sex trafficking, or including child sex trafficking, which everyone can be it was easy to say, well, child sex trafficking is terrible. We should make sure that doesn't happen online in any way we can. But what happened as a practical matter is that all kinds of sites just decided they wouldn't host anything really with any sexual content at all. And that made it very difficult for sex workers to find clients. So now they're on the street instead, which is much more dangerous. For my client, who's a massage therapist, to find clients on Craigslist, and so on, because what happens is companies over-censor when they're worried about when they're worried about liability. So, I mean, it's a tangle, I guess, is all I will say. But I don't want us to be naive on either side about the different tensions we have here.
If I'm not mistaken, Craigslist removed their personal section entirely after SESTA FOSTA passed. I think harassment is a very interesting issue because it, to me, often feels as though it's two issues bundled together, one of which can be more easily solved by the state or law enforcement, and one of which is just much trickier. And so harassment can refer to, criminal threats, real illegal or borderline illegal personal individual harassment, someone stalking or repeatedly sending threatening, nasty communications. But it can also apply to everyone disagreeing with you at once on the internet. Mm-hmm. And on the receiving end, that feels very harassing, but most of the people involved in it or carrying out the harassment may simply be sending one tweet, replying to a thread, disagreeing with your take as well ad nauseum. And so I think including both of those under the same umbrella has led to harassment, a tendency to treat harassment as just an unresolvable problem, when in fact I think it requires two very different sets of solutions. One much more on the state side, and the other, I think, with this sort of flooding, mass disagreement harassment, the solutions to that look much more like user tools to give them greater control over who can respond, who their tweets are visible to, or other sorts of messages. I don't mean to buy into a Twitter mindset here, but so I don't know how we can best unbundle that rhetorically or in political discourse about it. But right now it seems very confused.
I think that's a really good point because there are, I mean, one of the things that I get frustrated with over and over is when we have sort of seem to want to delegate to platforms something that actually the government can't accomplish. We not legally can't, but like they can't. Like we are, we don't have the law enforcement resources to deal with this problem. So but we think that the platform should. And you think, well, or maybe maybe that's actually not the right approach, and we shouldn't be actually asking websites to make those kinds of decisions, or to try to do what we cannot do. If someone's doing something illegal online, there are tools to go after that. And actually, in some cases, some of the more sort of famous harassment cases, legal tools were brought to bear. Law enforcement did come in, but you don't hear about that so much. But it is just really like, why are we deputizing the platforms to do what actually the state should be doing, and we are okay with the state doing? And then 100%, I would love it if the major platforms would just invest a fraction of the money that they're spending on hiring content moderators on developing user tools, so that actually users are in charge of their own internet experience. I think that is by far the most speech-friendly approach. And I'd like to see more of it. There are some proposals, there's some work being done in this area, but not enough. And Facebook, in fact, in particular, works very hard to limit any kind of tools being interoperable with its system. Like it wants to own the Facebook experience completely and not allow you to sort of put your own filter on it, which might make it a lot more fun for you to use.
There's something I wanted to follow up on based on a couple things that both of you mentioned, but especially you, Corinne, which is that you mentioned that harmful speech, but also removing speech can both be impactful in negative ways to marginalized communities. Can you discuss why that makes it so difficult for platforms to make the right decisions and for regulators to make the right decisions as well to protect these marginalized communities?
Yeah, I think it's because it is not easy, particularly if you're trying to delegate it to a robot, to distinguish between, for example, horrifically violent speech and documentation of horrific violence. So a sort of classic example was the Syrian archive, which was an archive of videos that was documenting violence in Syria and was really important, actually, as a piece of evidence. And but as you might imagine, those videos were horrific, and YouTube took them down because they violated their community standards, and they sort of didn't. It's very difficult to distinguish between, again, the documentation and just promoting it. And that's we see examples like that all the time, especially on the international level. It's just very, very difficult to tell the difference in an easy way, even if you bring humans into it, right? And especially when you're doing it, at a massive scale, it's just tremendously hard. And I get very frustrated with policymakers and other folks, speaking in the space, who sort of seem to think this is like a nerd harder situation. And it's not easy. Speech requires context. That's kind of how it works. And you can't, it's very difficult to moderate, quickly, which some new laws particularly require, takedowns within 24 hours. And how are you supposed to assess context with that kind of timeline? I don't see how you can do it.
Well, and I question whether that kind of context, the relevant context, is ever really available to content moderators, or as available as it is to the users involved in the conversation. And this again draws me back to the importance of agency and tools for users. I've been very excited by a product that Intel debuted earlier this year called Bleep. It's a real-time audio filter that the user can adjust. And they were mocked and pilloried when they rolled it out for including user toggleable sliders for slurs and various quite specific sorts of harassment. But at the end of the day, this is the most effective way of providing marginalized users with moderation that works for them, because how those what those slurs may mean to them may vary tremendously, whether they're in a small group chat reclaiming homophobic language, or playing games in a much wider, more public space where they're concerned about how those words may be used or directed at them. And no moderator is going to be able to understand, which of those two groups was the user playing Call of Duty in this time. That's a subjective assessment that I think only the user can make.
Excellent points. And following up on another thing that Will, you said earlier in the discussion, you mentioned that you're worried less about proposals to reform social media that would not pass First Amendment scrutiny. And Corinne pointed out that these can still be harmful because of the ways that platforms respond to them. Can both of you or one of you explain what these types of First Amendment issues are and how proposals might run into First Amendment issues?
Oh, well, I guess just to start, I see Sesta Fosta as sitting sort of right in the middle there, where it's not so clearly a First Amendment violation that I am or have ever been unconcerned by it. Again, when you're changing the rules for intermediaries rather than directly prohibiting speech, you can get away with a lot more, or it can simply be harder to challenge what you've done. I know that's played somewhat of a role in challenges to Sesta Fosta just sort of establishing real harm or standing. And I don't know if Corinne can get into that a little more.
Well, yes, I can. And the reason is, so EFF has challenged Sesta Fosta on First Amendment grounds on behalf of a group of or different kinds of organizations, human rights defenders, massage therapists, a group called the Woodhull Foundation that organizes a conference every year for sex workers and for around related issues to talk about that, and others. And so we've challenged Sesta Fosta, and there was an initial challenge based on standing, and the idea was you guys haven't alleged enough of a harm. And sort of the key thing that the government can do in this context is say, oh no, don't worry. Sesta Fosta is not designed to go after you. We don't intend for it to go after you, so don't worry about it. It'll be fine. And the problem with that is that the way that law, well, there's many problems, but one of the problems with that is the way the law is written. It's not just confined to whether the Department of Justice is going to decide to go after you. It allows a host of other entities to sue you. And one of the key things that Congress understood with Section 230 when it first drafted it was it wasn't just a problem of whether you might be liable at the end of the litigation, after a trial, at the end of all this stuff, whether or not you'll be liable for example, something defamatory on your site. That's one problem. It's the costs of fending off lots and lots of litigation, lots and lots of suits. Doesn't matter if you win in the end. By the time you finish paying all the lawyers, your website's finished. You can't afford it, right? You can't afford that litigation. And so it's really important that you be able to cut that off right away. And Section 230 allows that, but if you're being sued for a state tort, that's like libel of various kinds, and the other state torts. But so when they changed the rules, that made it difficult for my clients to feel safe, and they're always under threat from no matter what the Department of Justice said, unless the Department of Justice and every attorney general and lots of private people all promise not to sue us, we are at legal risk. So one of the ways that Congress basically helped create standing for us was to write a law that's really badly drafted and really vague. And so it puts lots and lots of people at risk. Now, unfortunately, until we're finished overturning it, there are lots of sites who are still going to comply with it because they can't take that risk.
Well, I
Yeah,
worry a little. Oh,
go
sorry.
go for it. Sorry.
I worry a little bit, even if you were to overturn it, that Craigslist wouldn't suddenly reopen its personals section again. I don't know, maybe just drawing from Dart, Backpage v. Dart, even after the Seventh Circuit ruled against Sheriff Dart, said that his threats to Visa and MasterCard were prohibited by the First Amendment. He couldn't threaten them to stop doing business with Backpage. They didn't change their policies. They didn't go back to providing services to this site because at that point the inertia was in the other direction, and I think they feared bad press if they changed course.
Mm-hmm.
And I worry, given the kind of politics that led to the passage of Sesta Fosta in the first place, if practically or vis-a-vis mainstream platforms, even a repeal probably wouldn't change their content policies or turn the clock back.
Yeah, that is a real risk. I mean, I think our clients would be thrilled. And I do. I mean, I think it matters. I think it's still worth fighting the fight and pushing back, so we can set the precedent. Because one of the things that also happens that we've seen in this space is it never stops with one proposal. Sesta Fosta was one thing, but again, there are so many proposals piling on top of it, that there really is. This is one of the things that we learned from the copyright wars is, like, you can never satisfy the folks who think their concerns are more important than the countervailing speech concerns. They will never give up. They will always want more.
And we've already seen FOSTA, unfortunately, used or proposed as a model for everything from opiates to firearms advertising. So I certainly take your point that a win here might put the damper on some of those other niche carve-outs.
Right.
Pivoting a little bit outside the United States, I wanted to ask either of you if there's anything that we can learn from other countries' approaches to online free speech and social media, both in terms of things that we should look for as examples, but also in terms of things that we should look for as cautionary tales.
Well, I guess I'm most concerned by historically Germany's NetzDG law. I think that provides a pretty stark example of what not to do, or at least what America ought not do, in its approach to internet speech regulation. The bill requires private platforms to make legal judgments about whether or not speech is lawful, and to do so on a kind of shot clock. And so this sets all of the incentives in the wrong direction. They're punished effectively only if they fail to remove content that turns out to be illegal. So they have every incentive to quickly determine that flagged content is indeed illegal, and not to ask too many questions along the way. And unfortunately, over time, even more reporting requirements have been layered on top of it. So they're not just making legal distinctions, but also handing this speech off to the authorities. This is very difficult for users or citizens to challenge. It's not the government making the call that your speech isn't legal, but instead a private firm under this, in the face of this kind of stacked deck. And so I see that as kind of the most concerning model. Now that is already out there and implemented. Right now, I'm very worried about the UK's online harms bill. It creates a category of lawful but harmful speech, which platforms would have an obligation to remove. And I think more so than the German proposal, simply because we share the English language with the United Kingdom, would have greater spillover, or would affect American political speech to a greater extent. There's more commonality in issues, concerns, and transatlantic interest groups that would be affected by the British bill, but may speak to or be composed of Americans.
I will flag another one that's also an English language one. Actually, before I say that, I actually did spend some time trying to see if I could find one that I thought was a great model, and I fell short. I'm sorry to say, things are not moving in the right direction. But another one that I wish more people were paying attention to is what's going on in Canada, because that also is. I think the thing about it is when the UK or Canada adopts a regulation, other people say, "Oh, well, that's a law-abiding democratic country. Maybe we should do what they did. That that it's not like an authoritarian regime where I would be worried. These are people more like us, free speech loving people." And in Canada, they have a proposal that's moving along pretty quickly right now, that does a lot of what the UK bill actually does, and also does a lot of what NetzDG does, but also create, such as the 24-hour takedown requirement, which is a real challenge. But the other thing it does is it creates a kind of speech czar. So it creates a speech commissioner that has pretty extraordinary powers. So they can subpoena you. They can actually come to your offices and inspect your equipment and inspect your practices and copy your software and see what you're doing in terms of content moderation. I mean, it's kind of extraordinarily invasive. And or alternatively, however, you can work with them. You can submit your practices to them and see if they'll approve it. And if they do, then you're protected. So we can see how this is going to go. I mean, it's basically like, so companies will work with the government to, and which gives the government extraordinary power over their speech moderation practices. And I think that's really worrisome. I think this bill that's in Canada, I think in the United States would not pass scrutiny. But Canada has a different regime. It's a Commonwealth country. And there too, it's organized mostly around things that people think are horrific. So child exploitation material, which everyone can agree is terrible. But it also has some lawful but awful elements as well. And again, the problem is, I think in our eagerness to try to take really horrific content offline, we end up sweeping up so much more, and we end up adopting rules and regulations that are going to sweep up so much more content and affect so many other kinds of speech. We're really going to regret it down the line. And the internet, I mean, I think if all these laws that we're talking about, proliferate everywhere, the internet's going to look very different from how it looks now. And the only thing what gives me hope is that the internet is actually not the social media platforms. There is more to the internet than Facebook and Twitter and Google. And I have faith in the techies, because those are my people. And I have faith that, they will continue to develop speech alternatives.
And then moving on to reforms that you think might be more positive, or at least have fewer negative side effects. Are there any potential reforms, either government-led or company-led, or anything else that you see as having fewer negative side effects and potentially being beneficial to users, that you would advocate for?
Yeah. So the thing that I feel positive about is that part of the conversations around changes to intermediary liability, people are also talking about what I think is a much more positive direction, which is interoperability and fostering competition. So one of the, I wish that I didn't spend so much of my week worrying about what Facebook does. And one of the main reasons I do is because the decisions that Facebook takes are so hugely influential. So what if what if that wasn't true? What if, there were a lot more options and there weren't sort of a few companies sort of buying up every competitive alternative that ever emerges? And also, what if, this is going back to our conversation around user tools, what if we had more practices and potentially rules in place that encouraged interoperability, that encouraged people's ability to choose other services, and then that will allow them to engage with the platforms or engage with internet speech under their own control. And I do think that is part of the conversation. And as I was saying earlier, I think some of the larger companies would prefer that it wasn't, because that's the real trouble for them.
So I'd like to see more narrow regulation of harmful user activities rather than content. Back in 2018, Representative Estes proposed, it was never passed, but proposed a narrow anti-swatting bill. It criminalized using emergency services to misdirect law enforcement to someone's house. Now, could that be misused? Potentially, I guess any law could, but at the end of the day, that's targeting the user who's chosen to do something wrong, to misuse the platform or the telephone and emergency services. And it's not trying to change how platforms govern content, but is going directly to the source. And so for different sorts of harassment, I think that's usually the way to go and has less spillover. As concerned as I am about some of the First Amendment implications of the case, I think that the fact that the Justice Department has pursued this troll, Ricky Vaughn, who during the 2016 election published thousands of memes telling Clinton voters that they could vote by text, they could call or text to vote. I'd rather see law enforcement at least attempt to tackle that rather than expecting all of these platforms to draw the line between jokes and political misinformation or digital voter suppression, and managing our democracy that way. At least in the case of this prosecution, Ricky Vaughn and the feds can have it out in court and we can come up with a workable standard there. When we just bicker and jawbone over Twitter and Facebook's constantly updated rules around electoral speech, we never arrive at any workable conclusion and no one ever seems satisfied.
And then finally, one last question from me before we move on to audience questions. And sorry, it's a very broad one, but where do the two of you see the debate around social media heading in 2022, and where would you hope to see it heading? Which I realize are often two very different things.
Well, I'd like to see a greater focus on user agency, and if we're going to have political or legislative conversations at the platform level, it should be about interoperability and enforcement, rather than content regulation. Beyond that, the worst harms we see tend to be issues for law enforcement. If they need resources or better training, perhaps we should talk about that. But I think for the most part, they have all the legal authorities they need. And around something like swatting, the positive changes we've seen have mostly been cultural within police departments. Unfortunately, going into 2022, I think re-election prospects will rule the day. And so we'll see an intense focus on political disinformation, the limits of acceptable campaign rhetoric, and efforts by both sides to work the refs. The discussion we've seen in the past day about Rep. Gossar's attack on Titan clip will just be sort of repeated over and over around little controversies of the day.
Yes, I think all of that is probably correct. I think that Congress is not done beating up on the platforms. I think calling the executives on the carpet is good political theater, and so we're going to keep seeing it. I think there are some proposals that I don't know which of the proposals. There really are so many on Section 230 changes that I can't tell you which one's going to have legs, but they do persist. So I think that's a thing we're really going to have to work on, and really, the task is going to be trying to explain to policymakers and helping them understand that the decisions they make will not simply affect the bad guys, or who they think of as the bad guys, but that regulating in space is extremely complicated and requires a level of nuance and commitment, and technological savvy that unfortunately we don't always see. The place that I'd like to see things going is to focus on competition and those kinds of approaches, focusing on interoperability. I think it's interesting to me what's going on with the Digital Services Act. In Europe, there were some initial proposals there that I think were positive overall. Then things have kind of gone south a little bit recently, but maybe there's now that policymakers are going back to the drawing table and thinking about, and one of the things they're thinking about in that conversation is interoperability, and also in some of the related regulation called the Digital Markets Act. They're thinking about competition issues in this space. So that may go in a good direction. And then the other thing that I'm hopeful about is more civil society efforts. So as I mentioned earlier, there's a sort of revamp underway for the Santa Clara Principles, where we brought in a lot of different organizations from around the world to collaborate on what is a set of principles that we can all get behind for content moderation that will be more fair and transparent for users and more protective of speech online. And I think that I'm very hopeful about that. I see a lot of people organizing around this issue. So that gives me something to look forward to.
All right, I'm going to take our first audience question here. This is a very loaded question, so feel free to take it in however way you want to. It's, how do you think social media should have handled the online speech that led to the attack on the Capitol?
I mean, I think we have to know which online speech we're thinking about here. Is it merely the idea that the election was stolen, that kind of stop the steal rhetoric potentially from the president that's seen as having caused this? Or are we talking about little groups organizing all over the place, both mainstream platforms and walkie-talkie apps? Those may warrant very different solutions. I know we don't have too much time here, but I think at the end of the day, what we've saw on January 6th was ultimately a government security failure that's unfortunately been pinned on platforms post hoc.
So I'll be a little bit, I think that's mostly right, but I do think that, again, I don't want to be naive. I do think that social media platforms helped make it possible because, people can find each other and organize each other. I mean, that for good and ill, right? It's also good for people to be able to find each other for other reasons, for, the Women's March. So I that's sort of the nature of the platforms, and that's a hard thing. Because it can be used in really dangerous ways. Now, personally, sometimes I think I kind of like my Nazis out where I can see them. And it's also my understanding that in fact, there were people in law enforcement who were actually tracking some of these conversations. And so actually having them out in public or in groups that law enforcement was monitoring, and I have to talk about whether that was appropriate or not in another way. But the point is that this actually wasn't, what happened on January 6th should not have been a great secret to law enforcement. And so I'm not trying to give, platforms a complete pass. I'm just saying that I think Will's not wrong, that blaming Facebook or Twitter for January 6th is, I think, missing some much more fundamental issues in our democracy that need to be addressed.
Content moderation is just a very inefficient way of stopping something like that from happening. Airbnb responded by ending all bookings in the DC area for a week. You can't expect platforms to regularly do that, especially when the underlying issue is something for law enforcement to deal with.
Excellent points. And then moving on to another question from the audience. Corinne, you mentioned that there were problems with requiring forum operators to allow users to opt out of or choose their own moderation. And this commenter wants to know if you can expand upon that.
Sure. So, several times over the past few years, different kinds of services have tried to basically, in different ways, sort of allow you to kind of put a screen over your Facebook experience, for example, or you as a Facebook user, take some of your community there and the information that's available on Facebook and use it in different kinds of ways. So just sort of different kinds of tools that will shape how you interact with Facebook in very different kinds of ways. I'm sorry, I'm being a little vague, but they really vary quite a bit. And Facebook has sued them out of existence, or threatened them out of existence, claiming that it's a violation of the Computer Fraud and Abuse Act, because Facebook's terms of service do not authorize these kinds of services. And so that's a real concern, right? Because it's also like the Computer Fraud and Abuse Act, which is woefully out of date and needs to be updated. It's very old. It criminalizes all kinds of normal activities, at least according to Facebook's version of the world. So violating a contract, violating terms of service could put you, or encouraging someone else to violate terms of service in one way or another, could put you at risk of criminal penalties, which I think, some courts, including the Supreme Court, have recognized like that's overstating the rule. But the point is Facebook's not allowing it. And if somebody as big as Facebook comes after you, you're just a little startup. You're just going to back down. You can't afford it. Or perhaps you maybe will let Facebook buy you, in which case now Facebook owns you. and meanwhile, users don't get the different experience. So that's the kind of thing that we've seen.
And then I'm going to do maybe one more audience question before I let you both give some closing remarks. So this one, this commenter says that Article 19 of the UN Declaration of Rights protects the right to seek and receive opinions, information, and ideas. And they want to know how you think that could apply to social media. Does it imply a right to read opinions and political speech on social media?
You might be able to see it that way, but it's unfortunately balanced against all kinds of other rights. And that's not even bringing in there's a separate document on corporate responsibilities under IHR law, which includes some expectations of prohibitions on violent or disruptive speech. So unfortunately, like a lot of international human rights law, it's sort of all a balancing act. And therefore, while Article 19, when read in exclusion, sounds nice and sort of this ironclad protection of speech, it's instead much more of a give and take between competing values.
I think that's true, but I do think that there have been various proposals that have been legislative proposals made around the world where it's been useful to push, for those of us who are concerned about those proposals, to push back and say, look, are you conforming to international human rights standards or not? And Article 19 is one of them. It doesn't mean that Will's quite right. It doesn't mean that there isn't a balance. But nonetheless, there is that sort of recognizing that is one of the rights that people have. And that's also part of what the First Amendment protects in the United States, the right to receive information, not just to speak, but to learn. Very important to keep in mind. So I still, when we're advocating against proposals that we're concerned about, we will point to these international standards and ask the question, like, can you conform to this? And if you can't, you need to explain why, and you need to justify this proposal. And I think a number of the proposals that we've talked about here today don't meet that. meet that standard. Even the balanced standard, they can't meet it.
Frankly, I think the Facebook Oversight Board has done some very interesting work with international human rights law and attempting to wed it to Facebook's primary value of voice. And in sort of stepping back and forth between the existing IHR standards and Facebook's commitments, they seem to have come up with an interpretation of IHR law that is significantly more liberal than what certain international courts have arrived at. And so I think it's novel both in how it's been able to provide a backbone for relatively liberal decisions, but also showing that some of the more restrictive interpretations are not baked in stone or necessarily the only path you can take from that language.
And now, before we go, I'll give each of you about a minute to give your closing remarks, what you most want us all to take away from today's discussion. Corinne, sorry, you can go first.
So I guess what I wish everyone would take away from this whole situation is that all of this is a lot more complicated than people want to recognize, and the rules that we make for particularly intermediary liability are going to have consequences that are far beyond the initial speech that you might be upset about in a given moment. And we have to know that. We have to know that Congress did something very smart when it passed Section 230 in particular. And I mean, impressively smart, to be honest with you. And I don't think we always see that from our legislators, I'm sorry to say. And any changes that we make to that law, I mean, I don't actually think we should change it, but however we talk about this, we have to do it in a way that really understands the massive consequences of even small tweaks.
Yes, I would say that despite the size and seeming permanence of FANG, the internet as it exists now is not static. This isn't a fixed, stable system, and it's always changing. In the past 2 years, we've seen TikTok rise as a real competitor to the current dominant firms, especially among young people who seem to be such an important trend-setting market share. Crypto is taking off, and all manner of decentralized applications currently oriented towards finance may come to have useful roles for speech. I'm very excited about Filecoin in that space. And as I think Corinne just gestured to, we need to be very careful when we're thinking about making new rules or making changes to the rules that we have, that we don't handicap a future whose benefits we can't appreciate yet, because the wrong kind of changes may foreclose that and foreclose it in a way that makes it very difficult to ever recognize what we've lost or could have had.
Excellent. Thank you both so much for joining me in this discussion. I think it was really interesting. I think we both heard a lot of really good points from both of you about the importance of free speech online and how it's very often that we can unintentionally limit that free speech when we're trying to do good things and improve user experience. I also want to thank our audience for participating in this discussion with us in the audience questions or just listening along. I hope that you found something interesting and productive out of this as well. And this is definitely a discussion that we at ITIF will continue to have. I'm sure EFF and Cato will also continue to have this discussion. And so I'm sure you'll be hearing from all three of us on this in the future. So thank you everyone for joining us. And that's the end of today's panel.
Thank you.